Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. One question that a lot of mock trial competitors have as they prepare for tournaments is, how much of my case can I script? Well, here's the deal with scripting. It does really depend on the person, on the individual attorney or witness. When I competed, I always preferred less scripting, but there have been plenty of uber successful competitors, mock trial masters, who liked to script as many words as possible of their performances. And the rules for scripting, in my view, also depend a lot on which part of a trial you're dealing with. So to maybe help you get a better grasp of that answer and help you decide how much of your performance you should script leading up to your next competition, in this video, we're going to go through the four major elements of a trial: opening statements, direct examinations, cross-examinations, and closing arguments, and talk about how much of those you can script as an attorney. Sound good? Let's hop in. So let's start with opening statements, because that's the first thing that's going to happen during a trial. Opening statements are the one part of a trial that can be completely word for word scripted. And here's why. In an opening statement, it's really the first time in a trial that you're talking, and so the chances of something you didn't expect coming up before you give your opening are very, very little. Additionally, in virtually every style of mock trial competition, objections aren't allowed during opening statements, meaning there won't be a time where you have to suddenly think on your feet. Because of all of those factors, you're totally welcome to completely script your opening statement. And honestly, I would recommend it. Because of those reasons, because you're not going to have to think on your feet, because you're not going to have to deal with something unexpected, being scripted to your opening statement and really, really prepared in that way is going to make you be able to give the best possible opening statement. Moving on to direct examinations. Direct examinations can be mostly scripted, but the attorney and the witness must be able to roll with punches. Direct examination is the time in a trial where you're most likely to encounter a sustained objection. You ask a question that you had planned, the other side objects, the judge agrees with them, it gets sustained, and now you can't ask that question anymore. Well, if you're relying too much on a script at that point, you're going to be toast. You're going to have no idea where to go next. You're going to be totally frazzled by the fact that you can't ask your next scripted question. But on the other side of things, if your direct examination is totally off the cuff and you're just kind of coming up with it as you go, there's going to be no flow to your direct examination at all. You're going to fail to use storytelling techniques, which are extremely important to giving a compelling direct examination. And as a witness, if you don't have a script to follow at all, you're constantly going to be searching for words, which is going to lead to you repeating yourself, rambling, and a whole bunch of other things that aren't good. So for direct examinations, if you want to script out your questions, and even if you want to script out a witness's answers, that's fine, that's a good idea. But you cannot be so tied to the script that you have no ability to adapt in the moment. You also might want to leave some room in your direct examination to respond to testimony or questions that your opponent asks during the round. So with direct examinations, scripting them is okay, but they can't be completely scripted because you're going to encounter things, you're going to run into things within a round that you didn't expect beforehand. And you gotta be able to respond in those moments or you're gonna flop and it's not gonna be pretty. Up next, cross-examinations. Cross-examinations are similar to direct examinations in that they can be mostly scripted. Now, when you're preparing a cross-examination, unlike with a direct, you're not also going to be preparing witness answers. So if you're an attorney preparing a cross-examination or scripting a cross, it's all you. So here's what that means. It means that you can prepare the points you want to make, the order you want to make your points in, and even to an extent, the way you want to phrase your questions. But what you absolutely cannot control are two things. First, the answers that the witnesses give, because this is going to be an opposing witness, a witness from the other team that you're dealing with. And the second thing that you're not going to be able to control is the trial that happens leading up to your cross-examination. Because here's what happens sometimes. You have your planned cross and your planned points that you want to make, and then the other team, for one reason or another, takes their whole case in a direction you weren't expecting, and suddenly one part of your cross-examination is pointless. It's not valid anymore. It's not relevant anymore. And so what do you do in those situations? Well, if you're totally tied to a memorized script in those situations, you're going to flounder. You're going to be totally lost. So all of that is why for cross-examination, I am totally fine with planning your points, planning the order you want to make your points in. And like I said, even if you want to plan how you're going to phrase some of your questions, that's fine too. But what I don't think is a good idea for cross-examination is being completely memorized. Now, the more experience you have, the longer that you've done mock trial, the more license you will have to script yourself less and respond well in the moment. But even as a beginner, even as someone who probably should be more tied to the script as you start to figure out the best way to phrase questions and you start to develop your instincts for cross-examination, even when you're at that beginning point, it's important to leave yourself some flexibility to be responsive, and it's important to go into a cross-examination not married to the script and willing to make changes if necessary. Because spoiler alert, a lot of times those changes are going to be necessary. Before we get into talking about scripting closing arguments, I want to remind you that you can schedule coaching with me. I'd love nothing more than to meet with you or you and a teammate or you and your entire team to go over whatever it is you want to go over. I can listen to you perform a part like an opening or a direct examination and give you feedback in the moment. I can teach on an area of mock trial that you want to learn more about. Or we can just have a Q&A session where you fire things at me and I come right back at you with answers. However you want to spend the time is entirely up to you. I love spending time with students on Zoom. So if you want to schedule coaching with me, you can click the link in the description on YouTube or in the show notes on podcast platforms. All right, closing arguments. Closing arguments can be mostly scripted, but you must, absolutely must, leave room for being responsive to the trial that just happened. If I had $1 for every time I watched a mock trial round and heard a scorer after the round make a comment along the lines of, man, I loved that closing argument because it responded to the trial that just happened, I would be a lot more wealthy than I am right now. Scorers eat it up when your closing argument brings in specific things that happened during the round. Maybe a specific line that a witness said. Maybe the fact that the other side didn't call a witness you were expecting them to call. Right? There are all sorts of ways to be responsive in a closing argument. And since scorers love it so much and they're the ones deciding the fate of your team, it is not an option as to whether you do it. You must be responsive during your closing argument. Now, your closing argument should absolutely never, ever, ever be completely off the cuff. Because if it's completely off the cuff, you're going to be far too tempted to simply talk about the witnesses that you dealt with and the things that you remember from dealing with them during the trial. And it's going to be unfocused, and you're not going to be able to paint a big enough, broad enough picture for the jury. So you do want a script certainly to start out with, and if nothing else, you want an outline of where you're going to go during your closing argument. But a closing argument cannot ever simply be a memorized speech, because if it is, you're missing a huge opportunity to boost your score by responding in the moment to the trial that just happened. So if you're thinking, okay, how do I script my closing argument? How far is too far? Script relevant portions, because you know some of the major stuff that's going to come out during the round. So script your beginning if you want to tell a story that relates to your case, right? Script that. You can script when you're breaking down the law and talking about that. But especially once you start to get to the end of your closing argument and you're bringing everything together, that's where you're going to want to leave yourself space to be responsive. And look, this isn't an easy skill to develop. It's something you'll want to practice leading up to a tournament. So instead of just giving a memorized speech every time you practice your closing arguments, pretend, give yourselves imaginary scenarios for what the other team did or didn't do, and force yourself to, in practice time, respond to them. That way, when you arrive at a tournament, you'll be prepared to respond in the moment to what another team does. So with closing arguments, they can be mostly scripted, but it is not an option as to whether you leave yourself room to be responsive, if, that is, you want to be a mock trial master. So I hope you can see through this episode a broad picture of scripting and the benefits of scripting, but also how scripting can hurt you. So figure out what works best for your style and your personality, take an approach down the middle, and use the advice I've given you, because through my experience, doing openings and directs and crosses and closings in those way where you can fully script an opening but can't really fully script the rest, that's the best way to go, and that's going to set you up the most for victory, for success, and being a mock trial master.